Major breaking news. The United States Court of Appeals for the Sixth Circuit has just issued a major 50-some-odd page ruling on whether or not machine guns are protected arms under the Second Amendment. Let's break it down when we come right back. Hey folks, I'm Mark Smith, host of the Four Box of Don, a proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and I'm proud to say the top voice of the Second Amendment in America. Thank you, 2025 Gundies Awards. All right, just as a reminder, before we get to the topic today, I'll be in Knoxville, Tennessee this weekend, doing a book signing and giving a speech at the Gun Owners of America Goals Conference. This is their second ever conference. I was there last year. It was phenomenal. It was packed. An amazing event put on by the Gun Owners of America and the good friends we have over there. And I will be there this weekend along with a lot of other great Second Amendment supporters. So if you're down in the Knoxville, Tennessee area, make sure you check it out. And I think it will probably also be live streamed, but you'll have to go to the Gun Owners of America website to figure that out. All right, folks, so we have a major decision out of the United States Court of Appeals for the Sixth Circuit, a 3-0 decision. Very powerful decision. And frankly, given the way the law works today, the correct one. And that is that machine guns are not protected arms under the Second Amendment. We've talked about this issue before. This is a world in which Mark Smith does not get to design the world in which I want to live in. That's not how it works. The way it works is this is the way the world really works. And in today's world, as I pointed out before, we simply cannot get today 5 votes on the United States Supreme Court to say that machine guns, fully automatic weapons, are protected arms under the Second Amendment. That might change down the road. But for today, that is not the case. And the Sixth Circuit Court of Appeals, and this is great news for the Second Amendment, and you'll see why in a moment, found that machine guns are not protected arms under the Second Amendment, which is exactly what we want every single court of appeals in America to find. I repeat, we want every single lower court in America to find that machine guns are not protected arms under the Second Amendment, especially applying federal law, because if we don't get that kind of a ruling, what might happen is the Supreme Court may have to seek, or there may be cert sought, and the Supreme Court may have to decide it. And we do not want a decision that is adverse today that machine guns are not protected by the Second Amendment by the United States Supreme Court, because it will foreclose our ability to maneuver and get that kind of an outcome down the road, maybe 5-10 years from now. So we cannot afford to risk that kind of an adverse decision on the Second Amendment and machine guns today in the year of our Lord 2025. Moreover, as we've talked about before, if the Supreme Court ever took a machine gun case, it would likely, at least in the short run, bump away what we really want, which is a ruling that semi-automatic rifles such as AR-15s and AK-47s are fully protected under the Second Amendment. So with that context in mind, I am very happy to report, I know it's counterintuitive, but it's true, I am very happy to report that the U.S. Court of Appeals for the Sixth Circuit found that machine guns are not protected arms because they are dangerous and unusual weapons. This is the ruling that we want today in today's world, not down the road, but for now, this is what we want to avoid an adverse ruling at the Supreme Court. Specifically, in this case of United States versus Bridges, the 3 judges said that, number one, they felt that they were bound by Heller and by pre-Bruin circuit precedent within the Sixth Circuit Court of Appeals that had already held that machine guns were, that a machine gun ban was lawful. And likewise, they also said that even if you analyzed it under Heller and Bruin, machine guns are dangerous and unusual weapons because they're dangerous because they can kill lots of people super fast and probably with collateral damage and things like this, and they're not that easy to control, unlike semi-automatic firearms. That was a decision by this court today, and it's unusual because there are under 200,000 of them. Now, I can make a lot of arguments against this, as can you, but again, in today's world, we want machine guns to lose at every step of the way for now and give us a chance to win down the road. We must survive this fight and live to fight another day, as they say. On the machine gun fight, we cannot afford the Supreme Court taking one of these cases because we will 1,000% lose them today, and we don't want that. So with that said, this court, if you're going to lose a machine gun case, I think that we lost about as well as we could lose this case here in the Sixth Circuit. First of all, and this is a lot of good news out of the Sixth Circuit decision, there's a lot of good things out of this decision. In the U.S. versus Bridges case, number one, the court undeniably said, and this is correct, that all arms, including machine guns, are arms under the plain text of the Second Amendment. The right of the people to keep and bear arms shall not be infringed. The correct answer, as we've talked about before, is any bearable arm at all is textually at the plain text level of the Bruin methodology an arm. It is a protected arm presumptively. Then the burden shifts to the government to show a historical tradition of some sort of firearm regulation that would warrant a restriction or ban on the particular arm that is being regulated by the modern day gun control law, in this case, machine guns. And that is exactly what the court found, that machine guns are dangerous and unusual weapons, and that Heller set the standard for so-called arms ban cases by articulating the historical tradition of firearms regulation that outlawed the carrying of dangerous and unusual weapons. So with that said, here is specifically what the court found, and then I'll give you the facts. So we'll talk about the facts for a moment, and you'll see why we don't want this case to go to the Supreme Court. But to begin with, here's what the court specifically found. Defendant Joaquin Bridges challenges his criminal conviction for possessing a machine gun in violation of 18 U.S.C. 922-0, arguing that the statute violates the Second Amendment facially and as applied to him under New York State Rifle and Pistol Association versus Bruin. For two independent reasons, we, the court, disagree. First, controlling Supreme Court and Sixth Circuit precedent that predates Bruin but remains good law today compels our conclusion. In addition, applying Bruin's text and history methodology, we conclude that Section 922-0 is consistent with our nation's historical tradition of prohibiting private possession of dangerous and unusual weapons. We thus hold that 18 U.S.C. 922-0 is constitutional both on its face and as applied to Bridges. Accordingly, we affirm the district court's judgment and the conviction. That's exactly right. This is a good outcome. This is the one we want today in 2025. Okay, now I want to talk to you about one of the dilemmas we face in the Second Amendment community, and this is a global issue. As we saw in Heller and McDonald and Bruin, we were dealing with law-abiding Americans who were denied their right to keep and bear arms. And we got very good outcomes in those cases. But then we saw Merrick Garland, the Joe Biden Attorney General, shoved to the front of the Second Amendment line a criminal case of Zaki Rahimi, where Mr. Rahimi was involved in like 5 shootings. He admitted that he had taken his girlfriend's head and beat it against the dashboard. A witness saw this allegedly, and then he shot at the witness. So the Zaki Rahimi was exactly the terrible kind of factual precedent or factual fact pattern that we don't like to see at the Supreme Court touching fingers with the Second Amendment, because the reality is this current Supreme Court does not like criminals. And that includes Justice Thomas and Justice Alito as a general matter. They don't like criminals. They don't like criminals. They're not going to be sympathetic to criminals. So we don't want criminal cases raising issues of the Second Amendment to, generally speaking, go to the Supreme Court, because we're more likely to lose those cases than if we have Boy Scouts and Eagle Scouts as plaintiffs in civil cases challenging ridiculous gun control laws under the Second Amendment. And with that in mind, this is the specific fact pattern of the United States versus Bridges. And you tell me whether or not you think it's a good idea that we would bring this case to the U.S. Supreme Court, which is not going to happen now because the defendant lost. But if it had been the reverse, the U.S. government might have sought cert, might have gotten it, and we'd have been in big trouble. Here's the fact pattern of the Bridges case. Tell me if you think this would be good for the Second Amendment to have this in front of, let's say, I don't know, Justice Brett Kavanaugh. Joaquin Bridges was driving on a highway in Memphis, Tennessee, when he almost struck a police vehicle. As police tried to stop him, he slowed his car, rolled down the window, and fired several gunshots. One bullet hit the police car and narrowly missed an officer's head. Bridges sped off, leading to a pursuit which ended when Bridges crashed into a concrete barrier. He crawled out of his car and officers arrested him and searched his vehicle. During the search, police found a loaded Glock 23 .40 caliber handgun with an attached switch, a device that allows a semi-automatic pistol to fire more than one round of ammunition with a single pull of the trigger. The Bureau of Alcohol, Tobacco, Firearms, and Explosives examined the gun and determined that it qualified as a machine gun under federal law. Bridges did not have a valid registration for the machine gun and does not contest that the converted pistol is a machine gun as defined by 26 U.S.C. 5845B. You see what I mean, folks? Now, the reason why I bring this up is this. In other contexts, usually you're only dealing with civil cases and, that kind of sort of thing. But in the Second Amendment context, Even though we have fantastic Second Amendment organizations like the Gun Owners of America, the Second Amendment Foundation, California Rifle and Pistol Association, Firearms Policy Coalition, and all these sorts of things, right? All these great groups all across the country, many of which we've covered on this channel. These are the cases brought by those groups that we much prefer to see at the Supreme Court level. What we generally do not want to see at the Supreme Court level are Second Amendment challenges brought by criminal defendants on fact patterns like Mr. Rahimi's, right? Or here, Mr. Bridges, right? Zaki Rahimi, Mr. Bridges, not good fact patterns, not good for the Second Amendment, not good for establishing good precedent, because as the old saying goes, bad facts make bad law. And we'd much prefer to go to the Supreme Court on good facts. So anyway, with that said, I want machine guns ultimately to be protected by the Second Amendment, and I ultimately want machine guns to be legal because I don't see a reason why they should be illegal. But with that said, we're not going to get there today. It's not going to happen. And therefore, as I've said before, for those groups out there and those people out there that are fighting the fight over machine guns, it's dumb, dumb, dumb. In my view, don't put in amicus briefs in machine gun cases. Don't fight for machine guns. Don't do it. It's stupid, stupid, stupid. And it's not that the arguments you're making are stupid. It's that strategically, we really cannot afford to have a federal court of appeals issue a ruling that says machine guns are protected arms in the Second Amendment and that they cannot be banned or they cannot be regulated, because there will be cert granted in that case, and we 1,000% have terrible, terrible precedent all across the board for the Second Amendment and machine guns that we will never get out from under. So don't do it. Now is not the time. And by the way, I'll just leave you with this thought on that point. If you want to see the catastrophic consequences of being dumb and shoving cases to the U.S. Supreme Court, basically knowing you're going to get kicked in the butt, take a look at the Skermati case out of Tennessee, where the transgender lobby, the transgender movement, shoved that case involving minors and transgender surgeries and gender reaffirming surgeries and all that stuff. The Skermati case from this last term. That was pushed all the way to the U.S. Supreme Court. And the U.S. Supreme Court said that, yeah, you can ban minors from having so-called gender affirming surgeries and medical care and so on. This ruling, by all objective views, has set back the transgender movement decades, because it's now set a precedent for every state in the country to ban this kind of care. And again, this point of this video and the point that I'm making here is not transgenderism, good or bad or anything like that. It doesn't matter. The point is, if you shove your issue to the U.S. Supreme Court prematurely and you get a terrible ruling against you, you're going to be stuck with that anti-ruling, that bad ruling from your perspective for decades, for generations. So don't push the machine gun case to the United States Supreme Court in the next 5 to 10 years until this court changes. Now, if you get, Supreme Court Justices William Kirk, Mark Smith, and Tom Grievin up there swapping out the three liberals, we can have another conversation about this. But until and unless that occurs, don't be pushing machine guns. It is dumb, and if it ultimately works in your favor, it will be a terrible blow to the Second Amendment movement, and we do not want catastrophic losses. As I've taught many clients and many students over the years, you can make many mistakes in life. You just have to avoid catastrophic mistakes. And pushing the machine gun case to the U.S. Supreme Court and pushing that to somehow win the case in the courts of appeals, in my view, is a catastrophic mistake when it comes to our Second Amendment right to keep and bear arms, because it will backfire on us big time. So anyway, with that said, I'm sort of weirdly happy that we lost this case on the Second Amendment in the Sixth Circuit today in U.S. versus Bridges. But again, that's my view. You can disagree with me all you want in the comments below. Tell me why I'm wrong. So again, I look forward to seeing you all in Knoxville, Tennessee at the Gun Owners of America event. Make sure you follow me on X, of course, at 4BoxDiner, and don't forget to subscribe both to YouTube and to Rumble. And I'm looking forward to talking to you all again real soon here at the 4 Boxes Diner.
Orders up. Table 2A.